All right, so this is for NTI Day, I believe is at 6, which will be Wednesday, March 18th. Today we're looking at case of rights of the accused. So you're thinking about, a lot of your cases, people have been accused of a crime. They're going through their due process. So we're really going to look at those cases today. Now, before I do, I want to talk about this is especially important for AP Gov, the selective incorporation doctrine. So selective incorporation comes from the 14th Amendment, and is underlined here in this snip I have, that says, "Nor shall any state deprive any person of life, liberty, or property without due process of law." So basically what that means, it kind of includes the Bill of Rights are also applicable to the states. But instead of just taking that understanding, the Supreme Court over a period of time has selectively incorporated each and every right: freedom of speech, freedom of religion, freedom from unreasonable searches and seizures, on and on down the list, instead of just doing it all at once. So that's why it's called selective incorporation. So that's important to the case of McDonald versus Chicago, where the court selectively incorporated the Second Amendment to also apply to state and local governments. So they basically said, not only can the federal government infringe at your individual right to keep and bear arms, but neither can state or local governments. All right, Fifth Amendment cases. So first, when I'm looking at the text of the Fifth and the Sixth Amendment, there's a lot in there. Looking at the Fifth Amendment, no person shall be held to answer for a capital or otherwise infamous crime unless on presentment of indictment by a grand jury, except in cases of military cases. So basically, if you're going to go to a crime, you have to be indicted. Okay, you have to have actually something charged against you. You can't just be thrown in jail with no presentment. Nor shall any person be subject for the same offense twice. That's double jeopardy. Nor shall they be compelled in any criminal case to be a witness against themselves. So that's where you get the famous plead the fifth. You can't be forced to incriminate yourself. Nor be deprived of life, liberty, or property without due process of law. Due process is a very important part of the Constitution. And unfortunately, kind of in today's society, due process is kind of getting a back seat. I give a really famous case if we were in class. So I talked about when we talk about these things like red flag laws. Donald Trump, was, I want to say in favor of them, but he said, I want to take the guns first and then due process later. And I'm like, well, that's not really how the Constitution works, right? When you're accused of something, the government just can't come in and be like, all right, you're guilty, and punish you, right? In order for something to happen, due process has to go forward. They have to prove their case. They have to gather facts. You have to be able to face your witnesses. I mean, there's lots of things that go into that. And then really one of the more interesting parts of the Fifth Amendment, nor shall private property be taken for public use without just compensation. This is known as the takings clause, meaning if we're going to take your property, it has to be for public use. So we usually interpret that something as, a school, a bridge, a library, something like that. The widening of roads, that was an example close to where I lived. And they paid you for it, and we'll look at it as well. In the Sixth Amendment, all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury where the crime was committed. So you can't, for instance, I can't say, well, you committed a crime in Richmond, but I'm going to try you in Paducah. Now, there could be some reasons to move a case, and we might talk about that eventually later, but you usually have to be tried where the crime happened. You have to be confronted with witnesses against you, meaning we can't, say, well, this person accused them, but we're not going to present that witness against them. You can compel those witnesses to come forth and to testify. And you can also call for witnesses in your favor and have assistance for counsel. So you have the right to a lawyer. Miranda versus Arizona. Okay, this is where your Miranda rights come from. Miranda was convicted of a crime. It's not really important what crime they were convicted of. And immediately confessed to his crimes. But later he stated, I didn't know I had the right to a lawyer. I didn't know I had a right to not incriminate myself. I've never read my rights. And so he sued, and the court ruled in favor of Miranda. And that's why when you get arrested, they now have to say you have a right to remain silent. Anything you say can and will be used to you against a court of law. You have a right to an attorney. If you can't afford one will be appointed to you, yada, yada, yada. The reason for that is because in this case, Miranda claims that he didn't know he had his Miranda rights. Or in that time, there weren't Miranda rights. But he didn't know he had those rights. And so the court says, all right, now you have to be read those rights. And that's why it's really important. Sometimes you'll see on shows like Law and Order, they said, did you Mirandaize him? Meaning, did you read him his rights? Because anything that you admit to before you're Mirandized is inadmissible in a court of law. So if you admit to a crime and they didn't read you your Miranda rights, they can't use that in a court of law. Okay? It's only after you've been read your Miranda rights that anything that you say can be used against you in a court of law. Kelo versus City of New London. This is it's called the Pink House case. This is Kelo right here, and this is her little pink house in New London, Connecticut. The government wanted to, New London was in this, I don't want to say impoverished area, but it was in a low socioeconomic area, and they were trying to stir the economy. And so they were going to take this property and they were going to give it to Pfizer. Pfizer is a drug company, and at the time they were about ready to come out with Viagra. So they knew that that was going to boost the economy in the local area. It would bring jobs and would just help the overall local economy. Well, I think her name's Susan Kelo. She said, hold on a second. The takings clause of the Fifth Amendment says you can only take my property for public use. This is clearly for private use because, Pfizer is a private company. And so she said the government can't take my property for a private cause. And so the court, in a surprising rule, in a 5-4 ruling, ruled in favor of the city. The 4 more liberal justices of the court, and then Anthony Kennedy being the swing vote, voted in favor of, the city and the state being able to take over these individuals' private property. And then the 4 more conservative justices said, no, public use means, for public use, like a road, a bridge, a school, something like that. It doesn't mean for a public benefit. And so the liberal justices of the court interpreted public use to mean, well, there's going to be a public benefit from, taking this property and giving it to Pfizer and allowing them to enhance it and to bring jobs and to improve the property and improve the economy in that area. And really what the sad thing is, because this case took so long and there's so much media around it, Pfizer never moved into that area. And so these people had their houses eventually taken and torn down, and there's nothing there. I think still to this day, it's just an empty lot. So kind of a really sad story all around. Sixth Amendment cases. So, a very interesting case called Coy versus Iowa. John Coy was tried in court for sexually assaulting 2 13-year-old girls. When the girls were testifying against court, they placed a large screen in front of him so the girls would not see him. The jury proceeded to convict him. Coy argued that this violated his Sixth Amendment right to confront his accusers face to face. And if you kind of think about that, a lot of people say, well, of course these poor girls shouldn't have to testify in front of this guy who did these awful things to them. But when you put a screen in front of him, does that not give a presence of guilt even before the jury comes out with their verdict? And the court agreed with him. Placing a screen in front of an individual while these girls testified gave the presumption of guilt before the jury had come out and deliberated and had come with their conviction or whatever. And so the court said, even though this is also a very horrible case and these girls faced, trauma, John Coy still has a right to face, and that means literally face his accusers. So you can't do it through closed circuit television or anything like that. In order for your evidence to be admitted, now there's some special circumstances when it's not, but unless your evidence to be admitted, you have to face that person in a trial and, give your testimony. And so in this case right here, they declared a mistrial because by putting that in front of him, it gave the presence that he was guilty before the trial had reached its conclusion. Gideon versus Wainwright. This is in AP Gov. This is one of our cases we have to know. Clarence Earl Gideon was arrested in Florida for petty burglary, and so he did not have enough money for a lawyer, and he claimed that the court should appoint him. The court said that Florida law did not allow for that. The court said that Florida law only mandated that death penalty cases had to have a lawyer, but not in petty crime cases. So Gideon, not being able to find a lawyer, defended himself, and he lost. He was imprisoned. So while he was in prison, he writes a petition to the Supreme Court where he says they should listen to my case. I think this is a violation of my Sixth Amendment right to counsel, and the court granted cert. So you got to think all these people who type up these big old fancy certs now to the Supreme Court, or petitions, to the Supreme Court asking for a cert. This guy basically wrote out by hand from his prison cell asking for them to grant cert, and they did. So, a really rare and kind of fascinating way to get your case heard by the Supreme Court. So the question is, does right to counsel extend to state courts and state cases? So it's another selective incorporation case. And the court ruled in his favor, saying that the right to assistance of counsel in any case is fundamental to a fair trial. Therefore, the Sixth Amendment applies to state courts as well as federal courts. And so they said, and there's Clarence Earl Gideon there at the bottom, they said that, in order to make sure you have a fair trial, you should have someone there that knows the law, that understands the law, that can present evidence in your favor, call witnesses, question those that are accusing you. It's obviously not very fair that the only people who would be able to have assistance or counsel would be those that afford it. And so therefore, that's why we now have public defenders who represent people in trial courts that can't afford them. And so now everyone, regardless of what sort of crime you committed, you have a right to counsel in that case. Now, this did not cover civil cases, which is kind of like our Seventh Amendment idea, your Seventh Amendment's idea that you can sue anyone if the damages are more than $20. This did not apply to that. This is applied to criminal cases. So kind of a good way to kind of understand the difference. Criminal cases, we're talking about, violators of law, that deals with the Sixth Amendment. Civil cases, that's where you're suing someone, that deals with the Seventh Amendment. And at that point in time, the court did not say that you had a right to trial or right to counsel in civil cases. So this just clearly dealt with the Sixth Amendment. All right, so that brings us an end to our Fifth and Sixth Amendment cases. Tomorrow's NTI assignment is just a quiz going over the cases that we talked about this week. We finished up with our First and Second Amendment cases, talked about our Fourth and Eighth Amendment cases, and then finished up today with Fifth and Sixth Amendment cases. So that would kind of bring us to an end with those cases. Friday is an off day. The school was originally scheduled off, so we're not meeting that Friday. Then next week we got some big cases, our right to privacy cases. I call them our 14th Amendment cases, which will cover everything from abortion to same-sex marriage to segregation to the right to die cases. I mean, they're all in there that we're going to look at next week. So it's unfortunate that we're not meeting in class because these are usually some really pot stirs of cases, but we'll have to cover them online, and I guess I'll see you next week. If you have any questions, feel free to email me. Otherwise, be good, stay safe, and hope to see you all soon.